No change there then. The floor is yours.
Right. Okay. Hello, everybody, and thank you for joining me. The heading given by Mr. Green to me was protecting one's family. So I'm going to talk about four things. I'm going to talk about wills. I'm going to talk about intestacy, that's where there's no will. I'm going to talk about powers of attorney, it's both types. And if I get time given to me by Mr. Green, I'll talk about cohabitees. Does anybody know a couple of basic expressions that I'll be using, which is executor? Do people know what executors are?
Yep.
Right, so executors carry out the wishes of the deceased if there is a will. And executors are sometimes wearing two different legal hats. So they may also wear a hat and call themselves or be called trustees. So a trustee is simply the name it has on the tin, namely that you are looking after assets or monies for somebody, usually a child or somebody who has got a vulnerability. So for example, they've got mental health issues. So an executor can be a trustee as well. And if one is making a will and even possibly is going to leave assets to children. So for example, if you were going to leave assets to your wife or spouse, but if she predeceased you, it was going to go instead to your children, but they were not of a majority, so they were under 18. You would be very wise indeed if you were to have two executors who were also trustees, because if you don't have two, the law will say, well, we'll appoint one for you. In other words, you make a choice of who you want as executors. If there's any possibility of children getting any assets, you have to have two. And therefore, if you don't appoint two, the law will do it for you, which is just, they go down a pecking order of people who are in line to be appointed as trustee executors. Am I making sense at the moment?
So far.
Just, okay, that's an honest answer. Thanks for that.
That's James, though.
Oh, I know that, and we spend a lot of time fencing. A particularly good reason for making a will. Well, let's come up with one or two at least. If you have a business and you don't provide in your will for where your business assets are going to go, then you either don't think much of your business or you've been badly advised. Because if you don't provide for where your assets go, whether it's a share of a partnership or rather a share of limited company, so shares in this case, if you don't think to provide where they're going to go on your death, you would be very remiss. And you would also want to make sure that if you are a shareholder in the company and you have a shareholders agreement with your other shareholders, you would want to make sure that the shareholders agreement and the will provisions don't contradict each other. So you would, for example, say in the will, I am providing this for my son, and in accordance with the terms of a shareholders agreement dated whatever. One can refer to the other, and very often should do. One thing that is another good reason for making a will in special terms. But before I do and go there, who knows the difference between a joint tenancy and a tenancy in common? Don't all talk at once.
I do, I know.
James knows.
Right. Okay. Well, for the others, there are two ways of two people owning land in this country, the United Kingdom. Either A, they are joint tenants, which means that on the death of the first, the survivor gets the entire property, even if the first has left a will leaving his share to Battersea Dogs Home. So in that case, joint tenants, the deeds trump the will. Compare that to tenants in common, where you're still joint owners, but you can leave your half share under your will to somebody completely other than your spouse if you wish. In that case, the will trumps the deeds. So if you think about a couple who own a house as joint tenants, the first one dies, the second one falls apart through grief and whatever and has to go into a care home. They end up in a care home, and all the law at present allows them to keep is just over £23,000. If they went the other route and turned their joint tenancy into a tenancy in common, they could do something different. So they could then make wills leaving their half share to their spouse for their life, so that on the death of the first, the second one gets the share of the house, but only a life interest. And the beauty of that is that when the local authority come knocking and saying, well, how much have you got? We want to calculate your care contribution. The surviving spouse can say, I've got half a house, I own it. And then when the care assessor from the local authority says, well, what about the other half? The survivor can say, hand on heart, I don't own the other half. I'm only looking after it for the kids until I die. And the point being that when you make a will like that, and it's reflected with the title deeds, having what's called a restriction on them, then the local authority can only include the half of the house that she owns when they are assessing what she's due to pay in contributions to her costs. Am I still making vague sense?
Vague, yeah.
Don't say it if I'm not. Ask me to go over it.
No,
Am I boring anybody yet?
I can't hear any snoring.
Right, okay. Point being, for middle-aged couples, and I'm talking about 50s and upwards, they should at least be thinking about changing their deeds from joint tenancy to tenancy in common if they are concerned about care costs. Right, does anybody know how the law of this country deals with the situation where there is no will?
Yes.
Go, go, go. Take the heat off me. Go on.
Well, it's intestacy means that you can't get granted probate. You have to get a letter of administration, and then the laws of intestacy applies. The estate is distributed according to those rules.
Okay, so if there is a married couple and neither of them have made a will and they have children, do you know how the devolution of their estates operates under an intestacy?
It's something like £250,000 goes to the spouse and the rest is divided amongst the children.
You're almost there. The
So I'll have
spouse
to look it up.
the spouse gets all the personal effects of her deceased husband. She gets £250,000, as you rightly say, but she only gets half of the remainder. She shares it with the kids.
Mm-hmm.
So that is another good reason why married couples and couples who are in a civil partnership or whatever should be thinking about making a will. So we've got three good reasons so far: business, care costs, and because the alternative, an intestacy, can leave a surviving spouse with far less than in fact the will maker, or testator as he's called, would have perhaps intended. Right. Does anybody, and James, you've got to keep quiet on this one because I know you know the answer to this one. Does anybody know what the threshold is for inheritance tax to be paid by your estate? Well, the answer is 325,000. But Gordon Brown, something like 8, 9, 10 years ago, no, it must be longer than that because Cameron was in for 4 years, wasn't he? Gordon Brown introduced the ability for somebody, when their estate was being totted up, to be able to add to it the unused band of 325,000 of their late lamented spouse. So you've got Mr. and Mrs. Smith. Mr. Smith dies, and he's given away 100,000 in the 4 years before he died. And strictly speaking, it is 4 years rather than 7. And his, yes, who's shouting at me? Paul.
No, keep going.
Mrs. Smith then dies, and when her executors, who have been appointed under her will, are tossing up how much and whether she should pay any inheritance tax and how much her estate is, as I said, her husband, he had a 325 band as well, but he used 100 of that by giving it to his kids in the 4 years before he died. So she's only got 225,000 of her late husband to add to her own 325 before her estate has to pay tax. And there's one more allowance. She's allowed to pass on 150,000 on to her kids, so far as it is referable to a dwelling house that she has lived in prior to her death. I think I'm getting a bit complicated, aren't I?
A tad.
No.
Right, okay. I've given you 3 good reasons for making a will. If you're not married, one of them applies, namely a business. If you are married, then I've given you 2 other reasons: care costs and to avoid the alternative of no will, because it won't do what you expect it to.
Can I ask questions?
Yeah.
Yeah, go for it, Kathy.
What if you're single with no kids, but you've got a will to leave your property and money, etc., to nieces, nephews, that sort of thing? But actually, how is there a way of doing it so that you don't actually get your estate included in any care costs that you might come across, like the other example you gave?
Well, there is nothing to stop you if you have got a jointly owned house with a partner who isn't a spouse,
No, no,
so you're a single person.
correct.
Much of what I've done, you can still do. Much of what I've talked about, you can still do, but it works better if you're married or in a civil partnership.
So you better get married, Kathy.
I've done that before.
Okay. Tried it once, didn't like it.
No, I did. No.
I've got some other business cards actually, Kathy, and they say divorce on the back. I haven't answered your question fully, have I?
No.
No. Much of what I've said you can do, but there are other rules that come into it. So, for example, with the care costs, if you were to transfer half the house to a niece before you died, no, let's not even have you dying. Let's have you needing care. If you did that, the local authority could come along and say, well, is she living there, the niece? Answer, no. Okay, we'll force a sale. If she is living there, they would then say, is she over 60? Well, clearly she's not, because you were only 45.
If only.
So at 60 is the threshold for anybody sharing a house to be kicked out. Does that make sense?
So, but if I left my house if I gave my house to half to a nephew, half to a niece, and stayed and lived in it for the rest of my life, and then they got it, would that work?
Well, let's see. You've got your 325 band. You haven't got your second band because you divorced. You haven't got your ex-husband's band, but you've got 325. And you've got the 150 for the dwelling house that you've lived in, that you're leaving to family. So you've got 475 grand. If that is that going to be anywhere near an answer? 475 grand, only in excess of that would your estate be paying inheritance tax?
What about care though? They'd still take it off you for care, wouldn't they?
Yes, they would. Your half. So normally, if you transfer some of your assets before you have a need for local authority care, and you can demonstrate that, then whatever you have transferred is usually home and dry.
Ah, right. Okay, that's what I want. Okay.
It's when you have a need for care, and you still transfer assets, that the local authority have got the power to even go to court and seek an order that those people who you transferred the assets to, transfer them to the local authority.
Right. Okay. With you. Okay.
Right. Okay. I have been talking for 20 minutes so far, and I wish I had a beer. So far I've talked about executors, I've talked about joint tenancy and tenancy in common. It's pretty important that you get your head around that notion. So if anybody wants to give me a call at any other time, I'll go through it with them. I've talked about, oh, no, I haven't talked about cohabitees. I have an average of 3 cases a year bubbling away in my filing cabinets behind me, where a couple were living together for many, many years. Much of the assets was in the name of the boyfriend. The house was in the sole name, and then they split up, and the girlfriend finds herself completely destitute. all she's got to help her is an Act of Parliament from 1975 called the Inheritance Family Provisions Act, in which she has to demonstrate that her needs justify either changing the will or changing the intestacy of her late boyfriend in her favour if he popped his clogs. And the cost of these sorts of court cases runs into sometimes tens of thousands of pounds. If you know anybody who is in a situation where they are not married and are living with a partner, they need, in my opinion, a cohabitation agreement where each has their own solicitor who can independently advise them, otherwise it can be called into question. Or, sorry, not or, but in addition to, wills that cover what they're entitled to on death, and the cohabitation agreement will also usually cover pensions and a commitment to nominate one, and change of that nomination would be a breach of the agreement, the cohabitation agreement. There's a deafening silence now. I thought I was getting uncomplicated, but I can hear Paul yawning.
Thanks.
Right, again, cohabitation. Get anybody you know in that situation to give me a ring. Last of all, lasting powers of attorney. These have been in now for about 12 years. Before them, 2008 was enduring powers of attorney. Shall I tell you, because you're all too tired to answer me, you little sweet things? Shall I tell you the main difference between the old powers of attorney, the enduring powers, and the present ones?
Please do.
The enduring ones, you would register with the government department when the person in question lost their marbles. The present ones, you register when they've got their marbles, and before they can do anything with their power of attorney, they have to register it. So the registration takes place at the beginning of the process, not at the end. So there's two types of powers of attorney. One is property and finance. Usually you can have up to 4 attorneys. And you should be thinking about this, Paul, if you haven't got one already, because you've got a thriving business. You need somebody to certify that the person, the donor, that's the giver of the power of attorney, has got their marbles and has got capacity and understands what they're doing. So that's 2 people involved so far, the donor, the certifier, and then up to 4 attorneys, although you can have more, it gets very clumsy. And then finally, you would have 1 person who is served with notice of the intention to register the power of attorney document in Birmingham at the Office of the Public Guardian. So that is possibly 7 people involved: the donor, 4 attorneys, the person who says that he's got his marbles, and the person to whom notice is given. Now, powers of attorney, if you've got 4 people having a power of attorney, how do they make decisions? Is it one, like the 4 Musketeers, they have to be all for one and one for all? Or is it going to be, sorry, that is called joint power of attorney, and it's very bad news because if one of those 4 people dies, the whole document dies with it? Or is it going to be joint and several, where one of them can make a decision on his or her own, but the donor can put a qualification in the document to say that I will allow one to do this on their own, but I want them to use their best efforts to contact the other 3. So that's the preferred, that's my fallback position all the time. If you've got more than one attorney, you don't want to deny them the right to make single decisions in pressing circumstances.
Who decides who can make the decision though, who the one is?
Well, that will depend on the terms of the document. That will depend on what the donor says in the document. So she may well say, or he may well say, whichever, that if there is I'm trying to think of the expression. What's the expression when you can't decide because 4 of you can't decide?
Carry on.
She can, the donor can provide in the document that one of the 4 has got the final say. Does that answer your question, Kathy?
Yeah,
I think
it's fine.
yeah. You also have to make a decision on whether the power of attorney becomes valid and binding either A, when it's registered, which is the preferred option, but then again, your attorneys will be able to go to the bank on your business for you from day one. Thank you, Mark. Very grateful. Mark Exley's just come up with the right word. It's such a lonely place up here, Mark, that I should have thought of it and didn't. You've got the other choice of either I want this binding immediately it's registered, or option 2, I only want it binding when I lose my marbles. The second one can end up in litigation because you might have 2 attorneys at each other's throats, each producing different consultants who have different views about the capacity of the donor. So what I'm saying is my preferred option is always to advise clients to have the power of attorney in place from the time it's registered. The attorneys have got the power from day one. Do you want me to talk about health and welfare powers of attorney, or shall I ask if anybody's got any questions now?
Go for questions, I think. Any questions?
I can't hear you.
Can I make a point and a question?
Go on then.
Go on.
The point, firstly, is that avoiding care costs with the local authority just means that you're going to be in the worst possible local authority care home. So sometimes it's not a great thing to avoid paying for care if you end up in an absolute hole. The other question, the question I've got is, how are wills being witnessed in this time of lockdown?
Good question.
It's a very good question. The nearest answer I can give is that the last wills I did, which was last week, the husband and wife testators ignored lockdown. and they went 20 paces over the road to their neighbours and did it in the front garden. So I'm hoping when I see the wills get copied back to me that they've done all that I asked them to do to make it properly valid. So the answer is it's happening on car bonnets. There are some firms of solicitors who have actually stationed solicitors. I mean, talk about ambulance chasing. They've actually stationed solicitors near to NHS COVID-19 testing devices.
Nice. Mark, ask the question out.
Thank you. Al, a number of people I know have had parents transfer properties into their name on the understanding that I think it's 7 years they can't be touched. But then I've also been told by other people that that wouldn't be the case, and that it would be a clear case of evading care costs or something of that nature. What's your view on that?
Well, two things come out of that. Two separate aspects. One is inheritance tax and one is care costs. The thing about 7 years is a misnomer. If you transfer assets in excess of £3,000 to somebody, let's go back to my earlier example and say it's £100,000 to a daughter, and you don't survive for 4 years, then the entire amount is clawed back into your estate. If you survive 5 years, 75% is clawed back into your estate. 6 years, 50%. 7 years, 25%. Over 7 years, nothing is clawed back into your estate. So the rule is actually a 4-year and a 7-year rule combined. It's phased between the 4 and the 7. But dealing with two things, actually, dealing with what James said, half in jest, but not entirely, about you can save an awful lot of money, but then end up in a shit care home. Yes, you're right. Or you can spend a lot of money, and then when the money runs out, you end up in a shit care home anyway. And sorry, what was your second point about care? About
whether
sorry,
local authorities will pursue people.
I've got a case at the moment where the local authority are suing, and they're suing my client, who's the 72-year-old attorney of her mother, who is in her mid-90s, and mum is quite lost capacity completely. And mum transferred about 150 grand's worth of assets to all her grandchildren, we say, when she had capacity. So the issue there is, and I'm trying to narrow down the issues with crazy Northants County Council, which is difficult at the best of times. I'm trying to narrow down issues and get them to tell me when they believe mum, who's 96 now, but was about 88, 89 when she transferred the assets, and she did it all online herself. I'm trying to get the local authority to nail it and say, before we end up in a courtroom, when they believe that granny or mum, sorry, began to develop a need for care. because their whole argument, you know, is going to say deprivation of assets. And the law says, and there's these wonderful regulations. If you go online and look up CRAG, C-R-A-G, I've got no idea what it's an acronym for, but the C is for care. If you go online, you'll see that they've been superseded by more recent regulations, but they are still referred to affectionately as CRAG. And still, basically, whatever the local authority want to say, still, the issue is, at what point did the donor give things away? Was he or she in need of local authority care at that point?
Okay.
So it can be 7 years, it can be 8 years, it can be 9 years.
But if they were living independently at that time and just decided to transfer their house into their children's name, for example, or effectively giving the house away, but continue to live in it, then they obviously could have done that for 5 or 6 years and then had to go into care.
Yes, exactly right.
Okay, thank you.
What has intrigued me, and I know that James is a little bit of a political animal. If I had the time and the balls, sorry, Kathy, to make this a freedom of information request, I would love to find out which local authorities exercise their right to force sales, Tory or Labour. I would love to know which local authorities were most prone to saying, well, we're going to come after you through the courts. Because one argument would say, well, Labour, because they want to supply more services to people in care homes. And the Tories would say, well, how are we going to keep the blue vote? I'm just absolutely fascinated by the politics of it.
It'd be down to money, Al. It'd be down to money. What councils could afford to pay and what they couldn't. The ones that will pursue for the money, the ones that are the most bankrupt.
Well, in this case, that is where court proceedings have issued that I'm involved with. What is fascinating is that the local authority avoid my questions when I say to them, are you saying that the 72-year-old, 73-year-old daughter is liable for deprivation of assets just because she knew about what her mum was doing? Give me a court case that is a precedent for that proposition, that she knew what her mum was doing, giving 150 grand to the grandchildren for university costs, for weddings, etc. She didn't have any part in it. Mum had full capacity at the time, but plummeted downhill 6 months later, we say. And now local authority are coming after both of us. Both the mother and the daughter.
Could that be resolved by the unitary elections next year, Al?
Well, the word on the street is that those unitary elections aren't going to happen, isn't it?
No, they were meant to happen
Of course,
in May,
Sorry,
but
yeah.
they've been pushed back a year.
Yeah.
So that will effectively remove that rather well-run council from the record books, albeit all their debt will transfer equally to the other two unitary bodies that have been set up.
That's interesting. Is that pucker? Is that? Wow.
Yeah, so the unitary, I think it will be split east and west, I believe.
No, I knew that. No, I knew that bit, but I didn't know that the proposition was that the debt gets split 50-50.
I think that's the reason why Daventry Council are spending all their reserves,
And so Corby.
So a Corby, I've heard that already about Corby.
because they don't want to basically be using their well-kept reserves just to try to offset the county council's poor financial management.
And still no collars have been felt.
Before it turns into question time, has anybody else got any other questions